Hello, welcome to Crime in Court, and my name is Heather, and this is episode 15 of the Canton Cover-Up, Commonwealth versus Karen Reed. We are on part 1 of the Canton 9. So we're going to learn about who these Canton 9 are, how they are related to this whole cause. As you can see, they are there protesting and expressing their First Amendment right to give their opinions in the street and to assemble and to give their opinions. They have that right to do so. So as you can see, they are doing that in the Free Karen Reed movement. They also have some Free Turtle Boy. They have Colin Albert was in the house, as you can see, and they are asking for justice to be done. They have an American flag. So I feel that these are patriotic individuals. This one man over here is wearing John O'Keefe on a sweatshirt. So maybe they are possibly, I don't know. I feel like maybe he's a cop or something. I don't know. I feel like I have no idea why I think that. I have no idea who any of these are. I feel like very patriotic looking at all of them, and my heart goes out to all of them, especially after having to go through what they went through in order to just express their freedom of speech. So anyways, I'm going to, this first episode, we're going to go over a video that I put out earlier yesterday as a preview kind of this episode. So you're going to see it's Ken Mello and his phone calls to report the Canton 9, and then it is the interaction with the police as they come up to engage with the Canton 9. So you'll see that on camera, and then I'll come back here. But before I do that, I wanted to just take care of a little bit of housekeeping. So when I had recorded Turtle Boy's prison diaries, the last episode that I did, at that point this had not come out yet, or this announcement he hadn't made yet, but that I'm going to tell you about right now. Hold on, let me make that bigger. So on Friday we got some news on the Turtle Boy blog, on the Turtle Boy YouTube page and everything. He shared the blog that he wrote, which was Canton Cover-Up Part 290. See, he's almost at 300. So the SJC, or the Superior Court, overturns Dedham District Court decision revoking Turtle Boy's bail for 90 days. And this is just a heads up. He is not out of prison yet, or jail, but he no longer has to serve the 90 days. It's illegal that they tried to do that. So this picture is actually of him when he was first arraigned and out on his own recognizance that first time that he was arrested. All right, so this morning, this was Friday morning, Justice Kafker overruled Judge McCullum's district court ruling revoking Turtle Boy's bail for 90 days. Judge McCullum was overruled because you cannot revoke Superior Court bail for more than 60 days, according to the law. This means that Turtle Boy will be out of jail no later than February 23rd. So he has about 11 more days in jail max. He might get out sooner. And let's see what they say about that. So Justice Kafker also ordered Judge McCullum to submit his reasoning for why Turtle Boy is in danger to the community by no later than 4 p.m. Because the only reason that they put you behind bars is because you're a danger to something or someone. And that is interesting that the Superior Court judge is now asking the District Court judge to provide more substantiated reasoning for why he put Turtle Boy in jail. So the law requires judges to explain why a defendant is dangerous in writing, but Judge McCullum failed to do so. After McCullum submits this, Justice Kafker will rule on whether or not to immediately release Turtle Boy from jail before February 23rd. So he may get out sooner. This is a massive victory for Team Turtle Boy because the state's highest court has ruled that a judge and prosecutor failed to follow basic protocol in sentencing a man who has not been convicted of any crime. It is humiliating for a judge whenever one of their rulings is overturned by a high court. If they screw up on something so basic, then what else did they screw up on? We hope that today's ruling is the beginning of the end of this unjust prosecution of an award-winning journalist, or AKA Aiden Turtle Boy Carney. Turtle Boy's next court hearing is on Friday, February 16th. So that's this Friday. The 23rd is the Friday after that. So he definitely will get out that Friday, the 23rd, but he might get out the 16th, hopefully, or maybe even sooner if Judge Kafker gets the info and rules before the hearing. But we do know that Turtle Boy has a hearing on Friday, the 16th, in Norfolk Superior Court. Judge Kafker's ruling will determine whether or not he shows up in shackles or on his own accord. So that is where we will find out if Turtle Boy will be a free man. We hope to see many of you there at 2 p.m. on Friday to support your to show your support for Turtle Boy. So if you are local, I am not. I would be there if I could because I really believe in this. But so if anybody's local and is thinking you might go, then go for me because I would love to go and just show my support for Turtle Boy at Norfolk Superior Court. And that's going to be Friday, February 16th. So I just wanted to get that announcement out of the way. And now we can get into the Canton 9. We're going to talk about all of the details here. So let me just set the scene for you. This is November 5th, 2023. It's a nice, warm or seasonably warm day out on I think it was a Saturday or a Sunday, and I know it was a weekend, and these 9 individuals decided that they were going to go out and express their First Amendment rights to a protest, to a gathering, to assemble, to express their opinions regarding a criminal investigation that they disagree with. And they so happen to be in front of D&E's Pizza, which is owned by, I'm going to say witness, Chris Albert. And he is the father of Colin, the brother of Brian, the homeowner. So Brian and Nicole, remember, are homeowners. And Julie and Chris are married, and they have the son Colin, who we think potentially and Turtle Boy has expressed openly on his show he believes, and I'm not saying this, but he believes that Colin and possibly Brian Albert got involved in some kind of struggle, some kind of violent something or other, and the dog got involved, and then that's how he got the injuries on his arms. And somebody hit him on the back of the head with something, or he could have fallen in the shuffle, whatever, and hit his head, falling backwards or something. I don't know, because he had the large laceration on his head, which was more than 2 inches long, I believe it said. All right, so without further ado, I'm going to play you the video that, get my sound ready. I'm going to play you the video that I created for the Canton 9. So here you go.
Yeah, this about recording Sergeant Slade speaking.
Is it the sergeant? Is that what we have?
Who would like to speak with, sir?
My name is Ken Mello. I'm a prosecutor with the Norfolk DA's office. Can I speak to the shift commander?
Well, I'm on duty right now, Lieutenant Two. How can I help you?
Okay, there's a protest going on outside D.A. Would you mind sending the car down here just to make sure that they're not intimidating me?
And what's your name again?
My name is Attorney Ken Mello.
And who are you working for?
I'm the special prosecutor
okay.
regarding Aiden Kennedy.
Got it. All right, so the prosecutor, you said there's people outside of DNA?
Right.
Okay.
Just have a cruise go by and make sure there's nothing.
We'll check it out.
Thank you very much.
Take care. Bye-bye.
You too, bye-bye.
Roger. Hey, Mike. I got a call from Kenneth Mello. He's the special prosecutor. Anyway, some protesters out in front of DNA, so Zeb's got to take a drive-by. Yeah, they can protest. I don't know, we're just going to take a drive-by. Just get the Chinese work, we should be sure we stop by to look. Yeah. So, all right, I'll get you. Bye-bye. Hi, Mr. Mello, Sergeant Slade. I just heard you. Hold one second.
Yes, sir.
Roger. Van officer swing by. So there's 4 people like across the street holding signs. They weren't right in front of or across the street. They're not impeding traffic, but so it seems kind of out with a small group now.
All right. Okay. Very good. Can you just here swing by there once in a while?
Yeah, no, we'll keep on making passes. You know.
Very good.
All right.
Thank you, sir. I appreciate it.
Sir. Have a good day. Bye-bye.
You too. Bye-bye.
Canton Police Officer, next record line.
Hi, Officer. This is Attorney Ken Mello. I believe I just spoke to the sergeant there. Is he still available?
He's not. He just stepped out. Actually, he's walking back in the room, sir. Hold on.
Okay,
let me put you on hold and I'll pick up, okay?
Thanks very much.
You're welcome, sir.
How can I help you?
Hi, Sergeant Ken Mello again.
No.
Do me a favor. Take a look at Chapter 268, Section 13A.
268.
13A.
Okay. Go to the book. Oh, 1 second, sir.
Okay. You give me a call back if you want, okay?
Okay, yes, sir, Mr. Mello. All right.
Okay. All right, thank you. Yes, sir.
Hey, Mr. Mello, Sergeant Slade. So, they looked at, so what do you want, what are you thinking of doing?
I think they're good enough to charge him, to be honest with you, at least this person. I mean, that's my take on it, you know, but it looks like they meet every single requirement of that statute.
Okay, so we just go up there, you want us to write a report and document who's there?
Yeah, if you could do that, yeah, please, if you can do that. I mean, you know, I'm checking you, Lieutenant. I want to, you know, I'm not an officer of your department, but I'm looking at that statute and saying they're across the street. They're certainly near Albert's place.
Right.
These are the witnesses, and they're certainly near the purposes of influencing or whatever else the statute states. Not there for any other reason.
All right. So it's punishable by no more than a year in prison and fine of no more than $5,000. So, correct. All right. So we go up there. We can try to figure out. I mean, I think we could probably figure out a couple of them. Not maybe not all of what they are. We can ask them, and they can just tell us, you know, how much I tell them, and we try to find them, you know, see where the cars they go to or whatever.
Yeah.
And then I guess we can go from there. Just you know.
Sure. I'm happy to reach you to see how she feels about it. Okay. Great. I appreciate it very much, Sergeant.
No problem, sir.
Thanks. Bye-bye. Bye-bye.
CvrUp the board signature, John.
They have papers in their hand. What are they going to do? Huh? Yeah. 4 cars. I know, there's 4 of them with papers in their hands.
Oh, we already know about it. How am I allowed to know that? I want to take a look at that. We're not doing it.
He's like protesting.
We get Okay. What does eyesight mean? Like directly in front? I mean... Okay, so... Yeah, I said like if he stands outside, is that on eyesight?
But where's the rest of it? Where's the rest of the statute?
That's the section.
Okay, but where's the section that Okay.
What if I just walk up and down?
I can't tell you exactly.
But technically we're really not eyesight. He's over there. We're in front of. Oh, so like.
I wouldn't say you have to run. What I'm saying is you can't sound shop directly eyesight.
Was it because we were yelling? Oh, because I was going to say we didn't yell.
Well, what are we influencing the witness doing? In discharge of because we're not anything for us to testify. We're not saying that. But that's what it is. So what does that? You don't want to debate it, but you're not. This is not matching what you're saying. How is it saying? Literally right here.
So we can move up a little. Yeah. We'll just move up a little.
We're not. But it's not that we're influencing just charge duty. We're not doing. It's not
That's our no.
Again, what we're saying is.
But what you're saying is this is a lie. It doesn't match what you're saying. We're not doing. They're
Keep it on video.
We're not saying.
My phone might die. Yeah, why? Oh.
So what tell us to go. Okay, so what are you going to do? Don't go. If we don't go.
All right, so I guess we can go on the other side. That wouldn't be eyesight, right?
Correct.
I mean, I could this way, but.
You can't see it. Where's the last thing of his eyesight? No. Wait, his eyesight? But if we were protesting,
Where does eyesight?
I don't know. They must not have body cams.
Tell Polina she's going to step out and give it to her. She doesn't. No, it's not even valid.
I'd love to put it on.
I don't want to.
Who wants to what? For what?
Don't give me.
No, we're not. But I'm why we want to.
We're not doing anything illegal.
I'm just curious.
You're sitting here with signs.
I know you're just doing your job. You're not wasting your time. You're not doing anything wrong. I'm not giving you my name.
We can't even call the state police.
Thanks for coming.
Just call them.
Thank you so much.
Thanks. Don't give me names.
All right, so there you go. That is basically the gist of the situation. Ken Mello called and tried to weaponize a unconstitutional statute and use it basically to make these poor 9 individuals felons when all they were doing was expressing their First Amendment right. All right, so we're going to read through Turtle Boy's blogs again because it really gives us a timeline, and he does provide a lot of the court documents, so he breaks them down and he highlights things. So this is all him. This is his. I'm giving him the work or the credit. I just am reading it out loud because he does a great job reporting this and giving us the timeline and specific information that we want to know. So November 5th, 2023, we're on the day that this happens. As you can see in this picture, this is Chris Albert poking his head out of his business, taking a picture of the 9 peaceful protesters. And this guy here, he's most likely taking photographs or trying to do some kind of facial recognition with the individuals so that they can charge them. All right, so Judge O'Malley issued an unconstitutional stay-away order that prevents me, Turtle Boy, from holding peaceful protests in front of D&E Pizza because the owner, Chris Albert, is a witness, kind of, but not really, as they say in the video, in the Karen Reed case. In doing so, the Commonwealth has effectively weaponized the witness intimidation statute to insulate anyone they deem to be a witness, potential witness, or family member of a witness from First Amendment protected speech. So this is, he gives us screenshots of the statute. A victim, if the alleged act was committed on or after April 13th, 2018. So that must be when the statute happened. Okay. So victim, witness, advocate, correction officer, court reporter, court interpreter, a person who is or was aware of information, records, documents, or objects that relate to a violation of a court order, or a family member of a person described in this section. So they can just say, hey, it's a family member of so-and-so, and they're a witness to a crime, so they're protected. It doesn't make any sense to me. All right, so a witness or a potential witness, a person who was aware of information, records, documents. I don't think we need to read all that, but so he's circling a witness or a potential witness. Well, any one of us could be a potential witness to a crime at any time. So a potential witness is everyone. So that is just very broad and not specific enough. This statute is so broad that you merely have to attempt to cause emotional injury, which includes hurting someone's feelings with your speech. So by saying Colin Albert was in the house, if that hurts Chris Albert's feelings, he can just call and say this is witness intimidation because I'm a witness. Which, give me a break. How long does your witness status last? Because didn't he already testified in the grand jury, or maybe he didn't. We don't know if he did. But if he did, then isn't it over? Like, isn't he no longer a witness because he finished? Like, he's done? I don't know. So, attempted to cause emotional injury to, caused injury to. So that is one of the reasons. So let's read this whole thing. So to prove that the defendant is guilty of this offense, the Commonwealth must prove three things. So to prove that it's witness intimidation, you have to prove these three things. First, the defendant willfully, either directly or indirectly, made a threat, attempted to cause physical injury, or caused physical injury, attempted to cause emotional injury, attempted to cause economic injury, attempted to cause property damage, or did those things, or actually caused those things, or you conveyed a gift, an offer, or a promise of value to the person to either take back their testimony, change their testimony, not to testify, whatever. You give them a gift and say, hey, I'll buy you a car if you don't testify in this case, or whatever. So that's first. But you also must prove that it was willful. So you have to prove that it was a willful act, that they tried to cause you damage, any one of those damages. And then second, the other person was a witness or potential witness, a person who was aware of information, records, documents, whatever. So I don't know if that's coming from the same section here. This is confusing. All right, so you can be charged with witness intimidation if you, quote, punish or harm a witness. So I think it was either Turtle Boy or it was Turtle Boy's attorney, Tim Bradle, that mentioned, what if, you have something happen between you and the witness, like you have a relationship with this witness, but you need to sue them for something, some damages, property damages or something that they did to your house. You just by putting that out there, by suing that person, that's causing economic and potentially emotional harm. It's stressful to go through lawsuits, yada, yada, yada. That could be considered witness intimidation, apparently, because there's no limits on this, no limitations, and it's not defined. And third, that the defendant did so with a specific intent to impede, so that they have to include that that the Canton 9 and Turtle Boy all had the specific intent to impede, obstruct, delay, prevent, or otherwise interfere with criminal investigation at any stage, criminal proceedings of any type, and civil proceedings of any type, grand jury proceedings, juvenile proceedings, or punish, harm, or otherwise retaliate against any such persons who is previously defined, or such person's family member, for participating in a criminal investigation. So there's so many, and this, and that, or that. So you could be considered witness intimidating for a number of things, apparently, in Massachusetts. So I would not try to live there if it was me. I wouldn't want to be caught with or charged with some bogus statute. All right, so if the police believe that you are attempting to punish or harm someone with your speech, they can then charge you with a felony, and it is a felon on your record. These 9 individuals who are peaceful, protesting very peacefully in the street, just trying to get their message out, now they have prison, fines, the thought of being a convicted felon looming over their head, all of that. So just think of that. All right, so however, I was one of hundreds of people Turtle Boy was one of hundreds of people who participated in the allegedly illegal rolling rally in Canton on July 22nd, and there was nothing illegal about it. So why am I the only one being charged? Is it because I have a large platform on Turtle Boy? Is it only against the law if you have a certain number of followers on Twitter? What would happen if a dozen or hundreds of people decided to protest these witnesses in Canton? If I didn't direct them to do so, it wouldn't be a violation of the stay away order, but would other people be charged the way I was? Is the only reason I'm being singled out because I have the microphone platform of millions of social media and website followers? A group of peaceful protesters headed down to Canton today to find out. What do you guys think? Do you think Turtle Boy is being targeted because he has a platform and he's local, so they can try to use their laws on him? All right, so here again we have the Canton 9. This gentleman right here holding the Colin Albert was in the house sign is a juvenile, and they charged him too with a felon. I'm going to keep saying felon. These people are charged with a felon. Turtle Boy too. All right, so they stood across the street from D&E Pizza and occasionally crossed the street to peacefully protest where I once stood. So Turtle Boy has protested in front, like right directly in front of D&E Pizza. I've seen it on his stream. He did it a couple times, standing there holding signs. One time, I think he was just by himself. It was him and his camera, and he was protesting, and it was pretty hilarious. But they didn't like it. They called the police, and the police came by and said, you know what? You have a right to protest. I can't do anything. You're not doing anything illegal. So just, mind your business and I'll be on my way, basically. All right. So when they did stand in front of D&E Pizza, Chris Albert came outside and filmed them immediately playing up his victim status, knowing that the police and the DA's office have his back unconditionally, knowing that he's got like this brotherhood behind him that's going to back him up, and reminded them that they are protesting in front of a witness. Quote, protesting in front of a witness, huh? Protesting in front of a witness? You must be proud of yourself. I said it all snottily, like I think he would, like... This is a man who knows that he can pretend to be a victim in order to weaponize the police and witness intimidation statute against free people that are just exercising their First Amendment rights in a free country. The arrogance is seeping out of his pores, just as it was when he told me that I was gonna get it for doing the same thing months earlier. Just as it was when he left the Board of Selectmen meeting last month and told my camera guy, we know about you. Like, what does that even mean? That's so stupid. Just as it was when he turned to his personal undercover cop at the same meeting. He had a cop with him at the Board of Selectmen's meetings. Basically a bodyguard. And he made sure that he was still there to escort him to his car. So he went out with his cop buddy. Just as it was when he called his cop brother, Kevin, who sent the police to disrupt my peaceful protest at his pizza shop. So Kevin, remember, is a police officer that works under Chief Berkowitz, who is the individual who found the last piece of taillight at 34 Fairview Road, which was, he just decided to drive by on a whim, and it happened to be shining out of the corner of his eye there, and he saw it, and he stopped and called others over and said, hey, I found a piece of evidence. Let's bag it up. Yeah, that's not suspicious at all. Days after the incident, but whatever. I digress. That guy who did that, Kevin, works for him. Kevin, the brother. All right, so Chris made sure to film everyone who was there and immediately got on the phone and alerted his friends at the Canton Police Department, who exist to protect and insulate him from free speech by labeling him as a quote-unquote witness, despite the fact that his son and brother allegedly helped to take the life of John O'Keefe, which Turtle Boy's saying that I don't know what happened in that house, but I'll let Turtle Boy stand by his words. I have trusted very much a lot of what he has said. He has put forth receipts on a lot of things, so my gut always tells me to go with Turtle Boy here. But anyways, so soon. Sorry, my dog is barking for reasons unknown. I think there's another dog in the neighborhood. Quiet. Shh, 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 shh. Okay. So soon after, a half dozen cops who should be thoroughly embarrassed to be doing this descended on the peaceful protesters and threatened to arrest and charge them with the same crime I've been charged with, which is the felony of witness intimidation. All right, so Officer Zeff, who responded twice when I was protesting outside of the same location. So it was the same officer who originally was in the video with Turtle Boy and said, yeah, you're fine if all you're doing is just standing there. I can't do anything to you. You have a right to protest. So he left. But now he comes and tries to charge or arrest or whatever, threaten arrest to these 9 Canton Free Karen Reed movement individuals who are out there protesting for a good cause. Right, so Officer Zeff, who responded twice when I was protesting outside the same location and told me my actions were perfectly legal, was one of the responding officers. He and another officer who couldn't contain his smile as he filmed the protesters with some sort of boomer iPad. Remember, I pointed him out and I said, it looks like he's trying to do some kind of facial recognition with these people. He had printed out papers. So Officer Zeff had printed out papers of this Chapter 268, Section 13A, which is the same statute that Mello mentioned on the phone. So they were escorted by a sergeant. So there was also a sergeant there. And we're going to look at some pictures. So here's the guy with the boomer iPad. And this is Officer Zeff with the papers. Here you can see a closer picture of them. And then there's some more cops coming from the back there. It's a blank page. Here's the sergeant. You can tell from the patches on his arm. All right, so here is the paper that they brought with them to hand to the Canton 9, as they are now and will forever be known. All right, so crimes and punishments, crimes against public justice, picketing, court, judge, juror, witness, or court officer. Which reminds me, Chris Albert is on the board of selectmen, and he is technically then, I mean, he's a public figure. He is a elected official, and there is no reason why people shouldn't be able to protest him, because taking that right away from the citizens is infringing on their First Amendment right. So you cannot do that. You cannot have a law like that is just, or statute is just unconstitutional. So, all right, so Section 13A, whoever with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing. So again, there's that intent of interfering, intent of influencing any judge, juror, witness, or court officer in the discharge of his duty, pickets or parades in or near a building housing a court of the Commonwealth, or in or near a building or residence occupied or used by such judge, juror, witness, or court officer, shall be punished by a fine of not more than $5,000 or by imprisonment for not more than 1 year, or both. So these cops went over there to threaten these 9 individuals with a $5,000 fine and imprisonment, potentially both. So that happened. All right, so Turtle Boy was charged with 4 counts of picketing a witness for the rolling rally, despite the fact that he was not intending to interfere with, obstruct, or impede the administration of justice. Chief Helena Rafferty clearly has a stack of these printed out at the station in case anyone else dares to exercise their First Amendment rights in Canton. If you want to be a free person, please go to Westwood or another community where, quote, witnesses don't live. But anyone's a potential witness, so witnesses are anywhere. Officer Zeff informed the protesters that Chris Albert was immune from being protested because he was a witness to a criminal crime. Someone may want to tell Officer Zeff that, quote, criminal crime is a bit redundant and you don't have to witness the crime itself to be a witness. The statute is so broad that even people like Chris, who has not been accused of being inside 34 Fairview Road, when his son and brother allegedly ended John O'Keefe, are immune to public criticism. So they're saying the statute is so broad that it makes him immune from public criticism, which is ridiculous. Especially since he's a public figure, you should be able to criticize them without the fear of retaliation. All right, so Officer Zeff wrongly told the peaceful protesters that they were violating the law because they were, quote, within eyeshot of Chris Albert. Nowhere does it say eyeshot in the statute. And they had to point that out. He says, you can't be in eyeshot. That was Officer Zeff saying you can't be within eyeshot. Can't be in eyeshot. He said it twice. They're just making up laws in Canton as they go along in order to protect a group of well-connected cop killers. And please spare me the excuse of these cops are just doing their job. The correct response when given an order like this is to refuse to do it. The problem is that we've trained police officers to blindly follow commands, which is something that has led to mass genocide on an international level when the wrong people gain power. But what even is eyesight? What if the witness is blind? Does the statute stop existing? What if they were hiding around the corner and couldn't see you? According to Officer Zeff, it meant that if the protesters could see the pizza shop, then they were in eyesight. Another picture, he says, we're in front of, can you see D&E? So the one guy asked, so what's eyesight? And he's like, well, can you see D&E from here? So that's basically what he's trying to say eyeshot is at this point. You can't set up shop directly in eyesight. Zeff also said that Chris was immune from being protested against because he, quote, appeared in front of a grand jury, end quote. That doesn't mean you're immune from anything. Get out of here, buddy. You're not special. All right, but how would the officer know that? Grand jury testimony is sealed. Chris Albert's son, Colin, was subpoenaed to testify in front of the grand jury when 2 FBI agents visited his dorm room. But to my knowledge, Chris was not. So, as far as we know, Chris was not subpoenaed. He did not testify to the grand jury, but apparently he's a family member of someone who has been. So that, I guess, qualifies him. I don't know. Zeff said he wasn't debating it when the protesters argued that they weren't intending to alter Chris Albert's witness testimony. Not debating it, he says. Which is good because there's no need for a debate. They have a right to be there, and that's the end of that. Zeph told them that the reason their protest was illegal was because they had signs that said Colin Albert was in the house, which Turtle Boy is saying, yes, he was, and they had signs that said Free Karen Reed. It says, you guys have signs. Colin Albert was in the house. We can't read. I don't think. Oh, and Free Karen Reed is probably what that caption was. It turned into we can't read. All right, so in doing so, the CPD are stating that it's the messages on the signs that are actually illegal in Canton, which is illegal to tell me that my signs are illegal and I can't say what I want to say. If the sign said Karen Reed is guilty, they would most certainly be allowed. I'm sure that Chris Albert wouldn't have had a problem with that. Zeph stated that they could protest anywhere as long as it wasn't in eyeshot of Chris Albert. He says anywhere. You can move anywhere. You guys can go anywhere you want. Not within eyeshot. So, but the town of Canton is full of witnesses in the Karen Reed trial. There are hundreds of names on the Commonwealth's witness list. Canton police have effectively prevented protesters from protesting anywhere in the town. Luckily, the protesters are skilled at the art of something that Alberts aren't reading. They showed Zeph that the statute didn't mention anything about being in eyeshot of witnesses. They had to point it out to him. And then he said, yeah, definitely don't see that in that 100% right. So he agreed when she pointed it out. There was nothing in there about eyeshot that he was trying to say they can't be with an eyeshot of Chris Albert. Wow. This guy thinks he's really something special. So Zeph also asked for their names and ID, which the protesters knew they didn't have to provide and refused to do so. He says, can you grab anyone's name? Who wants to? I don't want to. I don't know. Those were the captions. I have no doubt that Helena Rafferty is contemplating how she can charge this group of peaceful protesters with a crime. It wouldn't surprise me if she's drafting a criminal complaint as we speak. Either way, it's become clear that the town of Canton seems to believe that the First Amendment no longer exists simply because they have designated a group of well-connected people who are family members of cops as witnesses. That's a good paragraph. All right, so what would happen if dozens or even hundreds of peaceful protesters were to show up at the same spot and film themselves holding signs? How many people are the Canton police willing to arrest or charge for the crime of exercising their First Amendment rights? Maybe we'll find out. I will leave you with this piece of history. This is the end of his blog, but we've got one more we're going to get through, I think. So he says, I will leave you with this piece of history. In 1961, racially diverse, peaceful protesters jumped on two buses and stopped at interstate bus stops throughout the South to see if they would be arrested for exercising their rights to use segregated bathrooms. When they got to Mississippi, they were all arrested and sent to Parchman Prison, but this unlawful arrest only emboldened more peaceful protesters to come to Mississippi. The problem wasn't just the police, it was the law itself that needed to change. Within months, hundreds of people from across the country flooded the state and attempted to integrate their bus stop facilities, knowing that they'd be arrested. Eventually, the prisons became too full, and it forced the government to force integration. And that is how you create change effectively. All right, so the witness intimidation statute is as unconstitutional as Jim Crow laws. They have arrested me for violating this law, but I'm not a sympathetic person to many. What would happen if the town of Canton were invaded in such a manner by women, children, the elderly, and other peaceful protesters? Maybe we will find out. I can't currently do so, but to my knowledge, others without a stay-away order can. Nice. He says, in the meantime, please contact the ACLU to alert them of this blatant First Amendment violation. You can also call them this number here and email them at that email address. And you know what? I think I am going to leave it here because it's kind of a more positive note, I think, to leave it on. We'll get more into the court documents, and Turtle Boy breaks them apart in the next couple of blog issues, and we'll see some more protests and how the town is handling, and I'll update you then finally, like, where we are up to date. So with the Canton 9 and Turtle Boy and Karen Reed, at this point, still no federal dump. They're supposed to be dumping some information, they said, within the first couple of weeks of February. So hopefully this week they drop something for us, because we are supposed to be getting information regarding the federal investigation of the investigation into the death of John O'Keefe, because Josh Levy, the Attorney General, said that he would not let this trial go, with good conscience, he would not let this trial go forward because of the information that they have. So they do not, or this is coming from David Yannetti, but why would he I don't see why he would say that, out of turn in, under oath in a court. He said that, Josh Levy said that. So we'll see what comes of it. I'm looking forward to updating you guys as soon as I know anything. So I will share, probably in the community post, and do an updated video when I get a chance. Probably not right away. So just want to let you guys know I'm keeping an eye on the federal stuff, and I will let you know in a community post for sure when and if anything I hear from that. So thank you so much for watching. I really appreciate you taking your time today with me to go over this. This is so important, this First Amendment stuff, because it's so scary what the governments can do to us if we allow them the power and we as the people don't speak up. So I'm going to leave you with that note. Don't forget to call the ACLU or email them for reasons that you feel are against our amendment rights. And I will talk to you at the next episode. Thanks so much. Take care. Bye.